You put a gun to somebody's head. We're lucky you haven't killed somebody because that's the path you're on.
He pulls a gun on a 14-year-old kid and steals not only that kid's dirt bike, but also a small amount of cash from that 14-year-old. The PSI indicates that 14-year-old is so traumatized by this.
Imagine a 14-year-old kid simply enjoying his dirt bike when suddenly a gun is pointed at his head. This isn't a movie scene. It's the chilling reality for one victim in Jefferson County, Texas, who was traumatized by the defendant in today's case. Welcome back to the channel. Today we're diving into a case from a Jefferson County, Texas courtroom that highlights the critical balance between rehabilitation and public safety. We'll witness the sentencing of a young man, referred to as Mr. C or Mr. Chapa, who despite being young, had a concerning history of juvenile offenses and probation violations. The charges against him were severe: aggravated robbery, unauthorized use of a vehicle, and evading arrest. The judge's decision in this case serves as a stark reminder of the serious consequences that can arise when repeated opportunities for change are squandered.
That was not bad enough. He goes on to brag about this criminal activity on social media, and if that wasn't bad enough, Judge, he goes on to taunt the victim of the UUMV on social media as well. Judge, he is youthful. I'll acknowledge that. He does not have any adult criminal history, Your Honor. I will acknowledge that. But, Your Honor, what he has engaged in is beyond the pale. He needs prison time, in my opinion, Your Honor.
The prosecutor's argument that the defendant's actions are beyond the pale is a powerful legal rhetorical device. While acknowledging the defendant's youth and lack of adult criminal history, the prosecutor highlights how his conduct, especially bragging and taunting victims on social media, demonstrates a profound lack of remorse and an escalation of criminal behavior. This kind of behavior can significantly influence a judge's perception during a sentencing, as it suggests a defendant is unamenable to rehabilitation and poses a continued threat to the community. Such actions can be considered aggravating factors, pushing the court towards a more punitive sentence, even if it's the defendant's first adult felony conviction.
And that's what we're asking this court to do. If somehow, in any way, shape, or form, the court's considering community supervision, we'd ask for shock probation, some prison time up front, and then shock him out on community supervision. Judge, again, this is just beyond the pale. And I think the PSI speaks for itself. Thanks, Judge.
Mr. Chopin, these cases for me with kids your age are so hard. And I have for a very long time tried very hard to give chances. But all of the guns and the riding around and so you're January 2019, you're put on January of 2019, you are put on probation, juvenile probation. You violated it 1, 2, 3, 4, 5, 6. On your 7th time to violate, they finally sent you to TJJD, right? 7 times you were given an opportunity. You go to TJJD, obviously you're not there very long because you get out, and then in December of 2022, you commit an unlawful carrying a weapon, evading arrest or detention, and you're again put on probation.
Here, the judge reveals a critical piece of the defendant's history, a staggering 7 violations of juvenile probation, culminating in a stint at the Texas Juvenile Justice Department, or TJJD. This clearly shows a long-standing pattern of failing to comply with court orders and an inability to be reformed by less restrictive measures. The judge is highlighting that the court has repeatedly extended opportunities for rehabilitation, but the defendant has consistently failed to take advantage of them, committing new and increasingly serious offenses, including unlawful carrying of a weapon and evading arrest, even while on probation. This consistent disregard for the law and the court's authority is a major factor in her sentencing considerations.
You're given another opportunity in January of 2023. So in this year, you were put on probation for a gun case and an evading case. While you're on that probation, after you've been to TJJD, you commit these 3 offenses while you're on probation. So none of it makes sense that I want to do better. And I mean, all this riding around with guns and masks and stealing, and it's just crazy. It's just crazy. Got to see in the jury box. I gotta think about this one some more for a minute. So what I've done, in addition to obviously just thinking about it and looking at all of this a little bit more, is ask and get any incident reports that you've had since you've been in custody. And Mr. Chopin, I appreciate Mr. Lewis and what he's done and the arguments he's made for you. And like I said before, it really kills me to what I feel like I have to do to you young people. But we are in Jefferson County tired of young people running around here with guns.
This is a poignant moment where the judge expresses her personal anguish, but underscores her primary duty, protecting the community. In Texas, judges consider various sentencing factors, including punishment, deterrence, rehabilitation, and public safety. Here, the judge explicitly states that Jefferson County is tired of young people running around here with guns, signaling that public safety and deterrence are paramount in her decision-making. The repeated use of firearms in the defendant's criminal history, including putting a gun to a 14-year-old's head, necessitates a severe response to safeguard citizens. This also sets the stage for the affirmative deadly weapon finding, which has profound implications for parole eligibility under Texas law.
You put a gun to somebody's head, we're lucky you haven't killed somebody because that's the path you're on. You've had opportunities at probation, and unfortunately, those haven't worked. You've actually already had 2. You were sent to TJJD, you got out, you still committed offenses, and then you got probation again, and then you're here. So all this talk of I want to do right and I'm going to do better is just a bunch of baloney. The way you can't follow the rules in jail shows me same pattern. You can't follow the rules. So at this time, in cause number 23 DCCR 0993, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. I'm going to sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number, and these were all just open. So in cause number 23, DCCR 0991, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 0992, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative weapon, finding of a deadly weapon. These cases will run concurrently, which means together at the same time. So I am denying the state's motion to accumulate, which is a gift to you.
The judge's sentence is a complex one. For unauthorized use of a vehicle, Texas Penal Code 31.07, a state jail felony, he receives 2 years. For evading arrest or detention with a vehicle, Texas Penal Code 38.04, a third-degree felony if a vehicle is used, he gets 10 years. And for aggravated robbery, Texas Penal Code 29.03, a first-degree felony, he receives 25 years. The affirmative deadly weapon finding under Article 42A.054 of the Texas Code of Criminal Procedure is critical. It means the defendant must serve at least half of his sentence, or 30 years, whichever is less, before becoming eligible for parole. However, the judge's decision to run the sentences concurrently, rather than consecutively, is a significant gift, as she puts it. While 25 years is a substantial sentence, concurrent sentencing means he serves the longest term, 25 years, rather than the sum of all sentences. significantly reducing his actual time in prison. This indicates the judge still holds out some hope for eventual rehabilitation, even amidst severe punishment.
I am going to grant the state's motion to forfeit the weapon, which is a Taurus Millennium G2 pistol bearing serial number TIP10158. I'm going to hand you, I need there should be an admonishment showing that I signed it. It wasn't a plea agreement, but I don't see one printed out. Mr. Chopin, I take no pleasure in giving out a sentence like this, but I feel like what I have to do is protect Jefferson County from people like you, who have continued to show that you're just a danger and becoming more and more of a danger instead of learning from the opportunities that you've been given. You will be handed in just a minute a trial court certification in each of your cases that shows these weren't agreements, so you do have rights to appeal, and you can talk to Mr. Lewis about that. I hope you take advantage of any programs. You're still young. You're going to get out of prison and you're going to be young still and have a lot of your life ahead of you. I hope what you do while you're in prison is do what you're saying you really want to do, is get your life together. There's programs you can get out. You can have education when you get out.
In this Jefferson County, Texas case, the defendant, Mr. Chapa, was found guilty of multiple felony charges based on the evidence presented. For unauthorized use of a vehicle in cause number 23D-CCR-0993, he was sentenced to 2 years in state jail. For evading arrest or detention with the use of a vehicle in cause number 23D-CR-0991, he received a 10-year sentence in the Institutional Division of the Texas Department of Corrections. Finally, for aggravated robbery in cause number 23D-CR-0992, he was sentenced to 25 years in the Institutional Division of the Texas Department of Corrections. The judge made an affirmative finding that a deadly weapon was used, which affects parole eligibility in Texas. Crucially, she ordered all sentences to run concurrently, meaning they're served at the same time, which she described as a gift to the defendant. While the judge expressed no pleasure in delivering such a sentence, she emphasized the need to protect the community from individuals who repeatedly engage in dangerous armed criminal activity. Mr. Chapa was informed of his right to appeal and encouraged to take advantage of prison programs for rehabilitation. We will continue to monitor cases like these to bring you the most impactful courtroom moments. What are your thoughts on this judge's sentencing? Let us know in the comments below. Like this video and subscribe for more real courtroom analysis.